Election petition tribunals around the country have been busy with various legal issues emanating from the 2023 general elections. Among the state governors that the elections have been petitioned, Kano State is one of them. So on September 20th, the tribunal sacked Abba Yusuf, candidate of the new Nigeria People's Party, as governor of the state. The panel also ordered an independent national commission, INEC, to withdraw the certificate of return issued to Yusuf. The panel affirmed Yusuf Ganoa of the All Progressive Congress as the duly elected governor of Kano. Legal practitioners around the country have faulted the ruling of the tribunal, including senior advocate of Nigeria, Femi Falana. Joining us now on the show this morning is Kabir Akingbolu, a lawyer. Welcome to the show.
It's a pleasure for having me on the program.
Great to have you.
Thank you.
What are the issues as regards this case? Let's talk about the issues.
Yeah, the issues specifically as found by the tribunal was that some ballot papers were not marked. You know, they have no official mark of INEC. And basically, if you look at it very well, under the Electoral Act, there was nowhere where official mark was defined. However, in the manual and guidelines, official mark was defined to be something like a watermark. And now, if you go by that, it will be difficult for the tribunal to come to a decision without seeing the original ballot paper, because watermark is a security code, which is a security feature on the ballot papers. So, because the photocopy that was certified cannot be used to determine the watermark or the official mark, which is watermark. Now, Section 60 of the Electoral Act talked about result being signed, result being dated, and all that. That Section 60 is different from Section 63, which talk about ballot paper not having official mark shall not be counted. But as subsection 63 sub 2, it said the returning official can override the decision of the presiding officer. And under our electoral law, the presiding officer is the chief executive officer of his polling unit. And once he has passed the result and the returning officer has not faulted it or override the decision of the presiding officers, it has the tribunal has little or nothing to do, except where there is evidence before the court, because a court of law is not a magic arena where others are dished out for the mere asking. You must prove it. So at the end of the day, when the tribunal was hearing the matter, from the judgment of the tribunal, it was very clear that there was no evidence. The tribunal, in one of its findings, said we cannot go on a voyage of discovery to know why were the ballot papers affected, why they did not have official mark, that it was the respondents that should prove that one. It is not possible. It is the petitioner that must bear the burden of proof, because under the law, there is presumption of regularity to the result declared by INEC. So anybody who wants to fault it, one must come with sufficient evidence. Unfortunately, the tribunal said that they can't go on a voyage of discovery in one breath. On the other way, they turned around 360 degrees to say they have a right to look at the ballot papers to come to their decision. Those decisions were very contradictory, because evidence as says somebody must speak to those documents, but they were dumped.
Well, your argument looks straightforward. I've just double-checked Section 63, so you quoted correctly. However, the appeal is being heard today at the Court of Appeal Kano Division, sitting in Abuja. This discussion, are we not contemptuous of the proceedings at the Court of Appeal in Abuja? Well, because these are the same issues that the Court of Appeal is going to review.
Well, I want to trust that the Court of Appeal will do justice to the matter. And what we're discussing was the finding of the lower court. We're not talking about the merit of the appeal court, of the case pending before the appeal court. We are talking about the decision of the court at the tribunal, which is the decision of the court for now. So we can comment about it, but we cannot comment whether it will succeed on the Court of Appeal or not. We are not permitted to do that. It will be contemptuous.
But even us just talking about it, even bringing to light, why don't we just, and I see this regular pattern, that you have a case in court, lawyers want to come and argue them out, why don't you just leave the court to be able to make his decisions? And afterwards, then, the process continues. Because Because when you look at it now, like Dr. Bati was saying, I think we're subjudice here already. Because now you're talking about the merits, you're talking about technicality, you're talking about law. And in a couple of hours from now, I think maybe, in fact, I'm not sure, I think the court will have even started sitting now. Probably. A decision will be made on the case, and we are talking here, you know.
We can as well. We will wait for the decision of the court.
Anyway,
that is good.
Let us allow the Court of Appeal to do its
job. The
job.
court, please.
Because the same issues are about Section 60, Section 63, and compliance with the Electoral Act. So if we begin to look at the issues and all that, we'll be passing judgment, either by innuendo or by the first that are pushed forward. However, let me ask you, we've seen quite a number of cases in Plateau, at the presidential level, now Kano, and all of that. And one of the things that the commentators have said is that there are lessons already that we can learn from this process to guide us going forward, either to amend the Constitution or to review specific sections of the Electoral Act. As someone who has been following the 2023 electoral process, what are those key issues that you think will be necessary for review going forward?
For instance, the judgment in Osun and the judgment in the presidential, they have a lot of flaws. Like, for instance, if those judgments remain the law, it will be difficult for any petitioner to succeed on any election petition, except we say we should not file election petitions again. Because in Osun, for instance, the judgment was given that, before you can prove overvoting or non-accreditation, you must bring the BVAS report, you must bring the BVAS machine. How can you tender BVAS machine before the court for examination of the court? And that the report of the BVAS must be tendered as well as the manual register. Now, if this were to be case to go by the presidential election, for instance, they have done the states and the state governorship elections, the houses of assembly election, then later before the presidential. And immediately after those elections, the BVAS machine were reconfigured. So there was no how anybody fighting governorship election would be able to get the BVAS report or the accurate BVAS report or the BVAS machine, because the information that will be available now will be the one for the presidential, which is it is not the presidential came first. So if you have reconfigured for the governorship, all those people going for the presidential election petition are not joking, because you cannot get the BVAS. If the Supreme Court has said the only way you can prove those overvoting is by getting those BVAS machine tendered in court and the report. So these are the things. And again, when you are saying they cannot subpoena a witness, it makes it difficult for petitioners. For instance, we all know that INEC will conduct the election, make all their mistakes and all that, but because they know it will be difficult for you to prove it, they can just go scot-free like they have been going scot-free. And now, if they have done that, you are now saying, if you are preparing the petition, how do you get an INEC official or the returning officer to come and make statement on oath for you? So, and the Supreme Court is saying, the tribunal, Court of Appeal said it, the Supreme Court affirmed it, that you cannot do subpoena. You can't subpoena a witness. That will make it difficult for any petitioner to succeed in an election, because at the end of the day, if you ask INEC to come and do witnessment on oath, they will not sign it. This is the truth. So you must still use your normal witnesses. And the law is that INEC documents were prepared by INEC officials. So if they are prepared by INEC officials, only INEC officials can give evidence. But now our court is saying that you cannot subpoena them. And you are calling an adversary. How does it? You can only do that by subpoena, which is a court order.
So let's press it for, because in all of this electoral season case, let's talk about properly understanding the Evidence Act, because that's a big problem.
It is a big problem.
Can you
the Evidence Act,
yeah.
The Evidence Act said if a fact is to be proved, if it is a fact that must be seen, it must be the direct evidence of somebody who saw it himself. If it is a fact that must be heard, it must be the evidence of somebody who heard it by himself. If it is the evidence of something that should be felt, it must be the person who felt it that will say it. If you say somebody, no hearsay. If you say Mr. A told me that Mr. C killed Mr. Z, you understand, and you are telling the court will not believe you. But if you say I saw Mr. A killing Mr. Z, that is the direct evidence. Now, if the court courts have been saying that you have to bring witnesses from the polling units to come and give evidence before you can prove anomalies in the polling units. Then, and there's what we call best evidence rule too, which means the document speaks for itself. But our law, under the Evidence Act, it allows that document is the best evidence or the best evidence. But unfortunately, the courts over time have been saying that if you tender the document, the court will not be able to look at it, because looking at it will mean that the court is doing cluster justice in the comfort of their chambers. But I think it should be so, because you have 21 days to file election petition. It used to be 30 days. In 1983, Chief Obama did not file election petition, not because he was satisfied with the election, but he said the 30 days limited to file election petition was not enough for me to prepare an iron cast case. So if it was 30 days and it was short, then it's now 21 days. And you go to the tribunal, they say you should streamline your witnesses. In PDP, they have 27 witnesses. I think Labour Party has 13 witnesses. How do you prove election malfeasances, with few witnesses, when we have over 176,000 polling units across the country? And in the case of Buhari and Obasanjo, Petitioner of Best Memory said, to prove for a petitioner to succeed in the presidential election is a Herculean task, and that the petitioner must tender not less than 2,500 witnesses. So where are we today? So
okay. Two things. The presumption of regularity is in favor of INEC.
Yes.
And there have been so many comments about the role of INEC in this election. People have been saying, why is INEC getting away with it? Maybe just one comment about INEC, but the court seemed to take to go after the fashion that INEC is okay.
Yes.
What do we say about that? Earlier on, you alluded to the issue of the burden of proof.
Yes.
Is there something we also need to do in that regard?
Yes. Like, for instance, I would think that the court should be allowed to look at documents and make findings. Because for instance, in 170,000 polling units in a presidential election, assuming you are challenging 50,000 polling units, then how do you get the witnesses if they are not going to look at documents? So this is the thing. And again, this idea of saying the maker of the document should speak to the document, I want to believe that any official of INEC should be able to speak to INEC document, not necessarily the maker who is an official of INEC. So if these are not done, there is no way we are going with our electoral law. And because of this, that's why you see INEC conducting all sorts of elections. So I think we must go further here. Presumption of regularity inures in favor of result declared by INEC. However, the Supreme Court in the recent case of even Section 137 of the Electoral said the court, election tribunal, it's a new innovation in the 2022 Electoral. It wasn't in the old Electoral. That a court can look at documents and make findings if they are obvious on the face of the document, of course. But the Presidential Election Petition Panel and the Supreme Court said that provision notwithstanding, you cannot dump. You must still lead evidence to prove the anomalies you are alleging. So this is the situation here. In the Kano election, they used it. They said, oh, we are permitted to look at it. But in earlier, they said they are not permitted to look at it. So these are the things.
Well, Mr. Akingbolu, thank you very much for joining us on
It's
the morning show.
For having me.
We'll wait for the outcome of the session at the Court of Appeal.